Question. Detail the six fundamental freedoms, including speech, assembly, and movement, while highlighting that these are subject to reasonable restrictions. Hello, friends. Today we will discuss Article 19 of the Indian Constitution, which guarantees six fundamental freedoms to every citizen. Article 19 is one of the most important provisions in the Indian Constitution. It gives citizens six fundamental freedoms. These freedoms form the backbone of democracy, but they are not absolute. The state can impose reasonable restrictions on them in the interest of the sovereignty and integrity of India, public order, morality, decency, or to protect the rights of other citizens. Let us first understand the six fundamental freedoms clearly. The first freedom is freedom of speech and expression. Every citizen has the right to speak, write, and express their opinions, including through the press. The second freedom is freedom of assembly. Citizens have the right to assemble peacefully and hold meetings without arms. The third freedom is freedom of association. Citizens can form associations, societies, unions, or any other organizations. The fourth freedom is freedom of movement. Every citizen has the right to move freely throughout the territory of India. The fifth freedom is freedom to reside and settle. Citizens can reside and settle in any part of India. The sixth freedom is freedom to practice any profession. Every citizen has the right to carry on any occupation, trade, business, or profession. These six freedoms are very valuable, but the Constitution allows the state to impose reasonable restrictions on them. The restrictions must be fair, necessary, and not arbitrary. If a restriction is unreasonable, the court can strike it down. To understand how these freedoms work in practice, let us look at some important cases in chronological order. The first major case is Romesh Thapar versus State of Madras 1950. In this case, the Madras government banned a magazine for criticizing government policy. The Supreme Court held that freedom of the press is part of freedom of speech and expression under Article 19. The court struck down the ban and said that the state can impose restrictions only for security or public order, not merely because the government dislikes the content. The second important case is Brij Bhushan versus State of Delhi 1950. The government imposed pre-censorship on a newspaper. The court again struck down the restriction and ruled that pre-censorship is not a reasonable restriction on freedom of speech. A very significant case came in 1962, Kedar Nath Singh versus State of Bihar. The court upheld the law of sedition but clarified that it can be used only when speech creates a clear and present danger to public order. Mere criticism of the government is protected under freedom of speech. In 1973, the Supreme Court in Bennett Coleman and Company versus Union of India protected the freedom of the press from government control over newsprint and advertisements. A landmark modern case is Shreya Singhal versus Union of India 2015. The court struck down Section 66A of the Information Technology Act, which criminalized offensive online posts. The court held that the section was vague and violated freedom of speech and expression. These cases show the chronological development of the law. The Supreme Court started with strong protection of press freedom in the early 1950s, clarified the limits of sedition in the 1960s, and in recent years struck down overly broad restrictions on online speech. The main articles connected with this topic are Article 19, which guarantees the six fundamental freedoms, Article 13, which declares laws inconsistent with fundamental rights as void, and Article 32, which gives the right to approach the Supreme Court for enforcement of fundamental rights through writs. Friends, the six fundamental freedoms under Article 19 are the lifeblood of Indian democracy. They give us the right to express ourselves, to associate, and to move freely. At the same time, they remind us that freedom does not mean anarchy. The state can impose reasonable restrictions, but those restrictions must be just, necessary, and proportionate. In this way, the Constitution beautifully balances individual liberty with the collective interest of society. In summary, the six fundamental freedoms are protected rights, not unlimited rights. Through a series of landmark judgments from 1950 to 2015, the Supreme Court has strengthened these freedoms while allowing reasonable restrictions in the larger interest of the nation. Jai Hind, Jai Bharat.
Article 19 guarantees 6 fundamental freedoms, such as speech and assembly, but emphasizes these are subject to necessary and reasonable restrictions.
The 6 fundamental freedoms include speech, assembly, and movement, but these are subject to reasonable restrictions.
Article 19 details 6 fundamental freedoms, including speech, assembly, and movement. Crucially, these are subject to reasonable restrictions.